right, so we're back here, the Schiller Hamilton Podcast, and I'm Charlie Corrigan. I'm an associate here talking to partner Derek Harper.
Thanks, Charlie. Good to see you again.
How's it going, man? Yeah.
I'm doing well, man.
Let's do it. Yeah.
It's been busy.
Yeah, so I'm just going to ask you a few things. So you've been doing personal injury practice for over 10 years, right?
I started off doing family law.
Oh, right.
So I did that for a few years. I've been doing personal injuries, alone, as a exclusive practice probably for 6 now.
6, okay.
6 or 7 years now.
Yeah.
I've been doing them since, the beginning on the side, but been, my main practice for about 6-7 years now.
Yeah. Well, so in that case, you have a lot of experience with dealing with insurance companies. Yes or yes?
Oh, yes. You know how it is. Most of our cases are settled with insurance companies. So, day to day, that's what we're dealing with.
Yeah. So with no further ado, I'd love to ask you some questions about dealing with insurance companies because, you do it on a daily basis and you've done so for over 6 years now. So first things first, what are some of the, I don't want to say tactics with a negative connotation, but what are some of the ways that you've noticed insurance companies dealing with claims as far as certain pitfalls to be on the lookout for from a claims standpoint as far as medical treatment is concerned?
Okay. Well, first I could say, God, we could probably write a book about the tools and tactics. Like you said, kind of sounds, confrontational, but insurance is a business.
Yeah.
They're trying to save money. They're not in the business of paying claims. They want to cash your premium checks and minimize what they pay out. So I'm sure we could talk about it for days. But there's probably about, 5 or 6 things I've kind of keyed in on that are some tactics that they use to either discount your claim, discount your damages, stuff like that. So, before we get into medical, I want to kind of talk about what kind of happens first.
Yeah.
One of the first ones I would say that they do is kind of this like rush to get everything done. We have some clients that, they'll get calls within 24 hours of an accident from the at-fault driver's insurance company. And usually in that phone call, they're trying to resolve the case right there. They'll usually try to offer some money to the claimant and, try to get a release, within the first phone call, just so that they don't have to deal with it.
And not to cut you off, but so, you would be hearing about this secondhand after they make initial contact with the claimant or, potential claimant before a claim has even been officially started. But what have you been told by clients that, as far as how that conversation goes? Do they, on the front end, do they say, we're talking about resolving this matter right now? Do they mention that it would release any, just how does that conversation go about? Because I've never been party to one myself.
Most of from what my clients say is, those first contacts, they're wanting to get a statement. Okay.
Right.
And I'll talk a little bit more about that later because, the more information you give them, the more it can be twisted. But they're trying to get some information about what happened. They want to get a statement from their driver and the injured party just to see, if those statements kind of mesh as to what happened. So they want to get a statement, okay? Then usually they're offering some sort of money to resolve that case. And that may be part of a release and then a cash payment that's issued right then, and that's kind of the problem with these is that $1,000, $2,000, something like that is very tempting to a lot of people. Especially when it's just happened and they're like, send me a couple $1,000.
Yeah.
And I also think the insurance company, what they want to do is they want to get the case settled for as cheaply as possible, but they're also wanting to, get it handled before an injured person has the opportunity to speak to a lawyer. I think these insurance companies know that once a lawyer gets involved, they're not going to be able to play these games. And they're not going to be able to settle this case for, pennies on the dollar of what it's worth. I think that's kind of the main problem here is that, you should be cautious that those first contacts are going to be trying to get you to settle the case because if you think about it, if you just pause and think about it, why are they trying to do it? And when you think about why they're trying to do it, they're trying to save money, and they're trying to preclude you from having an attorney kind of advise you, then you should take a step back.
Right. And so going along with that, so what would happen if you're an injured potential claimant, just someone who got hurt, and the liability carrier who insures the at-fault party, the purported at-fault party, what happens when they offer, say, $1,000, $2,000 to, for the pain or the medical treatment that's anticipated, and then the symptoms reappear appear for the first time weeks later, and the treatment that's necessary and the diagnoses that are given are much more serious than what really the claimant initially thought, or what the insurance liability carrier would have even predicted. Well, what happens if you've accepted that amount and a few months later the bills start racking up?
So you've actually kind of segued into my next kind of tactic I was going to talk about, which is a conditional release. So usually that telephone call and any kind of check is going to be accompanied by some sort of release. Okay. So what you're talking about is what they call a conditional release. So that release will say something along the lines of, we agree to pay either X number of dollars of medical treatment, or sometimes it's included X number of dollars for X number of days. Sometimes it's, no cap, but a cap on days. Okay, so what that person's doing is when they cash that check and they sign that release, they're waiving their rights to sue that driver. And they're trusting that insurance company is going to promise, and I do it in air quotes because it's kind of vague as to what their actual responsibilities are as to what they'll have to pay. In exchange for resolving the case. So when someone does that early, just like you said, they may have that. Well, first of all, the problem is they do not know their damages. Most people do not walk out of an emergency room with a bill, especially not an itemized bill where you see exactly everything that was charged. Secondly, just like you said, you might not know the extent of your injuries. There's plenty of injuries that don't arise for 3 days, 5 days, maybe even a month or so later. Or the degree of that injury is definitely not known at that time. So that is exactly the problem. So to answer your question is, short of having an attorney, their options are limited. I mean, if they release that driver and cash that check, then they're going to have a very uphill battle to try to then file a lawsuit against them if they do find out, a couple months later that they need surgery or something like that. Now, you can walk them back. They can be voided. We have had success doing that. But it's definitely a limited window.
You had one recently, is that right?
Yeah, I had one where they're trying to use a recorded telephone call as a release. But then after that, they sent an actual written release and a check, and that's when the client came to us. We, of course, notified them that the offer was rejected and that they would not be accepting that offer. And they did push back saying, no, your client has already released our client, and we'll send the $1,000 check again. But yeah, we were able to basically push them on that, and we ended up settling that case for the true value of what it was.
Right.
But those scheduled releases or sometimes they're called scheduled if it's a time limit, and sometimes it's called conditional.
And one more thing before I forget. So just just so I guess people are aware who check this out. So you mentioned that sometimes, generally speaking, if you're not in this field and you wouldn't really have a reason to know how much, say, an emergency room visit would cost, maybe some CT scans, maybe an MRI, or even just X-rays. I mean, how much can just diagnostic tests in one emergency room visit be at any of the MUSC facilities? I mean, estimated.
An MUSC facility specifically comes to mind is in Lancaster. Mm-hmm. Obviously, I work in Lancaster and see that every day. I mean, we routinely see emergency room bills that are anywhere between $25,000 and $50,000.
Yeah.
And I would say the vast majority of these conditional releases I've seen have a cap of $10,000 in medical bills. So someone gets a call 2 days after the accident, and they are offered $1,000 cash, and they will pay all their medical bills up to $10,000 in exchange for a release. And the problem is once that insurance company, gets that bill, they may not pay that bill, and that person is now left not knowing what to do. They may have a bill. They may even be sued by the hospital to collect that debt. And so that's why it's so dangerous. You should never, ever sign anything or cash any check without at least talking to a lawyer. That's kind of the solution to all these tactics, is to at least talk to a lawyer.
Right. And this sounds self-serving. It's really not. I mean, no, but I know that you do this literally on a daily basis. Yeah. We get calls and in-person meetings all the time where, like, I mean, beyond free consultations, we literally just look at something and say, here, do X, Y, or Z. Probably as much as cases we actually sign up. So that is something that we like doing, just giving people that advice, and without, just because, we don't want people, we don't want to see people getting
no, this is information. We want this information out there.
Right, right.
Because we see all too many people who do come in and they've already signed that release.
Right.
And we can try to walk it back, but there's sometimes if the language is vague enough and things like that, that's how we kind of do it. And there obviously is duress there too, because this person's obviously under stress. But the vagueness is what really gets it, I think, a lot of times, is the fact that they don't know what their medical bills are. How could they contemplate $10,000 in medical bills as part of the contract? There's no meeting of the minds. We're not talking about contract law,
right? And if you're not familiar with the way that medical bills work and how inflated they can be, then $10,000 seems like a lot. I mean, that's nothing, as far as medical bills are concerned.
Yeah. And I would say the other thing people don't understand is this. Even if someone's out there thinking, oh well, what if the insurance company offered $100,000 on a conditional release? Problem is, if you have health insurance, you've seen it. I've seen it. Most people probably have seen it on their EOBs from their insurance company. Those insurance companies are paying pennies on the dollar. So what that insurance company is doing, even if they say we'll pay $100,000 and then give you $5,000 now, well, if they get that $50,000 ER bill and your Medicaid paid $500 of it, well, that insurance company is going to basically get off by paying that $500 reimbursement to Medicaid, and the rest of that money is going to stay in their pocket.
And why? So why is that important in South Carolina?
That's very important in South Carolina.
Why don't they want attorneys to have that information?
Because in South Carolina, well, they don't want claimants to know that.
Yeah.
Because in South Carolina, your damages are what you're charged.
Right.
So it doesn't matter, collateral source rule.
Yeah.
It does not matter what your insurance pays.
Right.
It be $1 out of that $50,000. Your damages are $50,000.
Right. So on $100,000 totality of medical bills owed, Blue Cross Blue Shield pays for 70% of it. 25% of it's written off. So you really only owe $5,000. A jury, they're going to award $100,000 if they consider all of those special damages. It's inadmissible.
Yeah.
So
exactly.
So going back to what you were saying earlier, I mean, that's I think that kind of is a pretty good example of why sometimes insurance companies are like, because
that's one of the reasons.
Don't talk to an attorney, because I mean, why would you necessarily know that that's about the collateral source rule?
And another thing that they do, another tactic people should watch out for, is they will say, because I've had clients tell me this several times, what they will say is, you don't need to talk to an attorney because it's going to drag your case on for years.
Right. And also, let me just say this, just to go back to what I said, that $100,000, that was purely an example for simplicity purposes.
Yes.
Don't want any adjusters listening to think that that's, I mean, if you get a $100,000 medical bill, you are in the hole as far as that. But anyways, just an example.
I know what you mean.
Yeah.
But I think that's another reason that they do it, is they try to scare people off from talking to an attorney. I think that they say, I think I've had clients tell me that the insurance adjuster will say, there's no way, you're not going to get more than this after you pay an attorney, which is usually patently false. And then also, it does take more time. Obviously, we're not going to be able to schedule, or we're not going to be able to settle a case within 48 hours of a wreck, but it's still just a tactic. These are just the things they're trying to, long story short, is both of these tactics are to try to resolve your case as cheaply as possible and before you can talk to an attorney.
Right.
Because most people know, most insurance adjusters know, they know that someone may not go to an attorney the next day or the day after a wreck or whatever. But what they do know is they want to get in front of them before they get in front of us.
Right.
And like you said, we're not trying to say everyone has to come to us, but just talk to someone.
I
don't think I've ever seen a personal injury practice that charges for a consultation.
No.
If you find one, then just go to another one.
Yeah.
But just use that free consultation at the very least. Talk about it. Tell the attorney what happened in the wreck. What kind of treatment you at least remember maybe getting at the ER. Like, again, you may not know your bill, but if you tell us that you had 2 CT scans, 3 X-rays, we can tell. And then if we're looking at a piece of paper where they're going to offer you $1,000 and you have 3 broken ribs, we can at least tell you whether or not you're going to have a decent case or not. And at the very least, even if you decide not to hire that attorney should, if they're worth their salt, is going to at least give you some knowledge so you know your rights.
Right.
And that way you're not. And what people don't understand is when you sign that release, you're waiving your legal rights away.
Right.
You're releasing that driver forever. Again, they can be voided, possibly. But if everything is done correctly and all the boxes are checked, you have now precluded your right. It doesn't matter if in 6 months you need massive surgery.
Right.
So that's the big thing first, is just that those first initial contacts with the insurance company are just chock full of different pitfalls and tactics that they're using to try to get your case done as cheaply as possible before you talk to an attorney. Yeah.
So next pitfall that I know that earlier you mentioned, we were actually talking about it coincidentally, and we've probably talked about this a million times, but tell me a little bit about the treatment gap conundrum.
Yeah.
Just go into that
So the gap in treatment thing comes up a lot. And I think first of all, adjusters live in this fantasy land. No gray area, black and white, very much just if you went more than 5 days without going to the doctor, then you must not be hurt. And there is some, that there is some legal basis for a gap in treatment, because they know that their attorney, if it ever got to that, their defense attorney is going to be able to put doubt in a jury's mind of what if something else happened. If you got in a wreck and you waited 3 weeks and then you went to the doctor, said you had back pain. Well, did you sleep funny? I mean, we're getting to the age now you sleep funny and you have back pain.
Right.
Or did you do something at home? Did you lift something? Was it a work injury? Anytime that there's something right there may be enough doubt, to get that jury to say, okay, maybe there's some sort of cause that breaks the chain of causation here.
Right. Or just the argument of like, were they really hurting if it took.
Exactly. But I think that's the basis for it, but they abuse it.
Yeah.
And like you just said, a few days, are they really hurt? That's kind of what we've heard. I've heard adjusters even tell me, well, your client waited, 5 days between going to the emergency room and going to the, their primary care doctor for a follow-up. Well, you and I in the real world and everyone in the real world also knows that it takes time to get into an appointment.
Right. And one thing that I've seen, I've seen 3 times now, specifically, is a situation where a client doesn't, one, where there was a family doctor, we call it primary care physician, 2, where there wasn't, where in the medical records themselves, I think one was MUSC Chester and maybe the other MUSC Lancaster, and then I think maybe Piedmont. Anyways, in the records themselves, which, something being in the records is important, but also it was obviously said by medical personnel, clear letters like, if this doesn't get better in 24 hours, if it gets worse, come back to the emergency room. Then the adjusters or defense attorneys, dealing with litigation, say we're not going to consider the emergency treatment for day 2 or day 3 because it wasn't necessary. Why didn't I've heard people say, why didn't you go to urgent care? Why didn't you do X, Y, or Z? Well, if you are hurting, first of all, you're following medical advice. Secondly, if you call your primary care physician, hey, when can I come see you? What about, insert date 3 weeks from now on a Tuesday, where they can just refer you somewhere else. What if you actually are hurting, you want to go somewhere, and if you wait that amount of 3 weeks, like this is part of the the conundrum, then they're saying, how much are you actually hurting? So it's like it really is like a damned if you do, damned if you don't situation, right?
It is.
Like in a lot of cases.
We talk about that all the time. It's like, okay, did you get too much treatment or not enough treatment?
Right.
And there's no gray area. I mean, there's no middle line.
Yeah.
It's either always too much or not enough.
And when insurance companies or defense attorneys representing insurance companies, when they say you got too much treatment, what does that look like? What are they really meaning as far as the effect of that when they're saying there was too much treatment?
Well, usually that's kind of coupled with, we didn't think that you were injured this bad.
So they're not going to cover the excess of that magic number?
A lot of times we see it with either physical therapy or chiropractic treatment. Maybe specific things that happened in those treatments are not by the book of what they say should happen. Meaning, like, if you go to physical therapy and they do this, 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 and this, well, maybe they should have only done this, this, and that. You know what I mean? And then especially with chiropractic treatment, they'll do the same thing. They'll say, okay, well, this was too much treatment because, the standards or whatever the industry standards that they're using to evaluate things say, oh, you should only go 3 days a week, and you cannot have, say, you can't have massage therapy and chiropractic manipulation in the same visit.
Right.
So a lot of times those are just, arbitrary tactics that they're saying. But then also, like I said, they may say, like you said, they go to the ER, someone does not have health insurance. Okay, so that pretty much, if they don't have health insurance and a means to pay, that's going to preclude them to go to pretty much any private doctor.
Right.
So even some urgent cares. I mean, we have private urgent cares that you don't have insurance, then it's going to be $200.
Yeah, I mean, copay $100 minimum.
Yeah.
Like,
and so, a lot of times the only avenue someone has is an emergency room. It's the only place they're going to get to go and not be turned away.
And someone tell them, like, you're okay or, like, you're not. I mean, there's a legitimate concern of, like, am I, everyone hears stories about what happens when people decide not to go to the hospital, and it's, devastating. So, I mean, everyone's heard those stories.
Exactly, especially with head injuries.
Yeah.
We see where they may not catch it the first time. But then a couple of days, the person may be, the client or injured party may be experiencing, more fogginess. Maybe they had a fainting episode, something like that. And they're like, okay, this head injury is worse than I thought. And like you said, a lot of times their discharge paperwork, if they don't have a primary care physician, will say, return to the ER. So that's a big thing. But, what I want people to hear too is the fact that if you're dealing with this on your own, you don't necessarily have to trust that insurance adjuster to say, oh, well, we're not going to cover the second time you went to the emergency room.
Right.
Because, again, they can say whatever they want to say. They're not attorneys. You don't have to trust them. In fact, you should not trust them at all.
Yeah.
And so that's the thing we like to talk about is the fact that don't let them say the gap in treatment and stuff to, defeat your case. Don't let them use those tactics against you. That's kind of what I want people to know about.
Right.
Because like you said, everybody's probably going to deal with this at some point, and many of our clients deal with this exact kind of thing, whether they go back to an ER or, it takes 3 weeks to get into their primary care physician. With COVID, we had it, I had several cases from 2020 and 2021 where it may take 3 to 6 months to even get an appointment.
Yeah.
A specialist, maybe you're referred to a specialist and that specialist says, okay, well, we can get you in, but it'll be in September, and what are you supposed to do then? And that insurance adjuster is probably immediately going to tell that claimant, we're not paying for that.
Yeah, and again, that's assuming that they can even get that referral. And like you said, I mean, it's without a means to pay and health insurance. I mean, like,
they're going to use any gap to basically say that it's not covered, and there's plenty of legitimate reasons for that.
Yeah, if it even occurs in the first place.
Exactly.
Yeah, but
so that's kind of like, that's probably one of the bigger ones with medical, like how they kind of use your actual medical treatment against you.
Right.
That
kind of reminds me, I also want to ask about this. Just not sure how we're doing on time here, but real quick. So while we're talking about medical treatment, like go into what we were talking about. We've also talked about this a million times, and about the pre-existing medical condition.
Yes.
Issue.
In fact, yeah, you're right. We've talked about it. We've actually even had a podcast about it.
Yeah.
But pre-existing condition raises its head a lot as well. Partly because some of the pre-existing conditions generally almost anybody has. I mean,
degenerative disc disease. People don't realize. I mean, it's
if you're over,
isn't it like 40%?
Yeah, if you're over 30
55?
years old, yeah. I mean, I think over 30 years old, you're probably going to have some level of degeneration in the discs in your back.
Yeah, and clients are always shocked when I point it out to them. They're really going after the degenerative disc disease. They say, "Wait, what?" Because they're like slip disc, herniated disc. I'm like, no, it's just spinal narrowing. Basically, it's really common. But I mean, there's been more often than not, people are pretty surprised, and it's been in their medical records from years ago. Like point being, it's very common.
Yeah, and what the insurance companies will try to do, that adjuster is going to try to say, okay, well, you have degenerative disc disease, Charlie, and you were in this, relatively minor accident, and so we don't believe that your back pain now is from that. And what they try to do is they're going to
from the accident.
They're going to try to say, well, your back pain's from that. It's not from this accident. Fortunately, what happens is, or what should happen is that at-fault driver and then the insurance company that they are insured by are liable for changes. So that's what we talk about in that podcast, but I can kind of tell you a little bit. So like if you have a baseline of your injury or your condition before the accident, and then it's elevated, it's either temporarily aggravated like a flare-up, or it is changed, worsened permanently, they're on the hook for those changes. And then another one we see too is that an insurance company will say, oh, well, what happened to you, Charlie, is, I'm just using your name.
Yeah.
What happened to you is unforeseeable or unreasonable. And the average person would not have gotten hurt in that way. But there's tons of reasons that someone may be more highly susceptible to, like I said, a degenerative disc disease.
Right.
If someone has a nearly herniated disc and they didn't know about it, or a pinched nerve or something, they didn't really know about it, or something so close, and then they get in a wreck, well, it may be a minor wreck, but it may have pushed, it may be the final straw.
Right,
so
the straw that broke the camel's back.
It may literally be the straw that breaks that disc's back.
Yeah.
And you may need to have a disc arthroscopy or an artificial disc.
Or decompression surgery, where there was already stenosis existing, and this made it so where the pain just became unbearable with the pinched nerve.
And so a lot of times they may say, well, you were hit at 20 miles an hour in a parking lot. There's no way. But that person was highly susceptible. And that's what we talk about in that podcast is the eggshell plaintiff doctrine. The fact that, it doesn't matter how unforeseeable it is. If it's something if you have some wild condition that you don't even know about,
right.
You may have some genetic disorder that you literally have never known your entire life, but it makes your bones more brittle.
Yeah.
You never knew. And you're walking around like Mr. Glass.
Yeah, I was just thinking Mr. Glass.
And you something happens to you and you suffer some catastrophic injury. You never know.
Yeah.
It doesn't matter how unforeseeable it is or how rare it is. But that's usually flipped against, by insurance adjusters a lot of times. And I think Joel and I talked about that in that podcast too. And I keep referring to that. Y'all can go watch it if you'd like. But what happened is a lot of times these insurance adjusters will kind of misconstrue the eggshell plaintiff. Even if we have a sophisticated claimant who has heard of it or knows about it, that adjuster is usually going to try to use it. And I don't know if they misinterpret it on purpose or what, but they'll often try to say that means that your higher susceptible condition is basically your own fault. Like, just because you're an eggshell does not mean that we're on the hook. So the pre-existing injuries thing is a huge problem. I think the biggest problem is it may scare people off from going and getting the treatment they need because in those initial consultations, or if they've sent their medical records to an adjuster and they're saying, I'm still having problems, and that adjuster's saying, well, you have back problems before, they may be scared off.
Right, because they don't want to get more treatment if they're concerned that it's not going to be covered. Exactly. They're thinking it's going to be sunk costs. They're going to be even more in the hole than they already are.
Exactly. And, it's critical in those types of cases to get an attorney, just because, like I was telling you too, it may be a temporary worsening, it may be a permanent worsening. So that's a huge difference. If someone has an injury that they had before and it's flared up temporarily, maybe they have some treatment, physical therapy, it's back to normal, or back to what it was before, maybe not back to normal.
Right.
But the problem is when people have an injury and it's accelerated so fast, especially any kind of joint injury. I've had clients before who've had, say, knee problems before. They maybe already had arthritis in their knee, and they suffer a slip and fall accident. I know we're talking about car insurance here, but very similar. A slip and fall accident on that knee, well, they may recover, but then their arthritis may be accelerated. And so that's a lifetime change. So all of that stuff is very critical. And anytime you have an adjuster who's mentioning, pre-existing conditions and pre-existing injuries, you definitely need to see a lawyer.
Yeah, I mean, moral of the story here is just, I mean, like there's nothing to lose as far as getting a consultation. Like you said, if, plaintiffs firms, personal injury firms, they ought to give free consultations. We do all the time. And it's just worth it. I mean, you don't know what the motives are for insurance companies. Like you said, they're a business, the whole business being collect premiums, don't make payouts. That's the name of the game. It's, it is what it is. So, these are some pitfalls that, I mean, like clockwork, even when an attorney is representing you, they still, I mean, all the way up to in front of a jury, they're going to go for these arguments. So without an attorney, if you don't know what the counter arguments are and you don't know how to combat these arguments, like it's pretty harrowing and it's overwhelming. And, you think that these are, experts that have experience, they're not pulling this out of nowhere, and they're kind of not, but it needs to be combated, whether it's through an attorney or with knowledge that an attorney gives you if you want to undertake it yourself, right?
Yeah, and when we were talking about this morning before we started this, what we were talking about wanting to get out there is just the information to watch out for.
Right.
Because again, I think a lot of people would trust an insurance company. And they're going to trust that adjuster because it's a professional person.
Are you in good hands?
Yeah, are you in good hands? Exactly. They think, they maybe think of their own insurance company and in instances that they've dealt with their own insurance company, but you're an adversary to that insurance company.
Right.
You're a dollar sign. I have a friend, and his quote, I love it, is you would never trust someone who owes you money to determine how much money they owe you. And that's basically what you're doing.
I hadn't heard that.
If I had loaned you $100 and then I said, hey, Charlie, how much do I owe you? And you're like, $70?
Yeah.
And I was like, sure. No, that's not how it works.
That's
so
funny.
That's the kind of the thing to look about it. But every single thing that you do, and the other thing I wanted to talk about is that they're going to use things against you. Okay, one of the other things that people may get nearly immediately is going to be a medical release. Okay, which we have to get a medical release from our clients as well, so that we can get their medical records and their billings. But if you do that through an insurance company, it's usually broad, and most of the time it has no definition at all. So lifetime, if they wanted to. If they wanted to spend the money, they could get your entire medical history. So one thing I always tell people is, please, before you sign that, talk to a lawyer, because, again, they may pull 5 years of medical records. So one, it's an invasion of privacy. It's information they do not need, that's not relevant. And they're going to nitpick every single thing they find. They may find a pre-existing condition. And if we have a client that has a pre-existing condition, we may share those prior medicals, again. But we're doing it with our client's interest at heart, and we're only doing what we need to do.
And we qualify it. We say
exactly. Exactly. They may look back through a medical record and they may dig into, 5 years ago you came in and you had a positive statement that you were using illegal drugs. I
mean, or they just say nothing, right? We've gone through medical records, blanket statement, and a lot of these issues were already here, and there's some other stuff that's
what I'm saying. They may try to pull things out. They may find things that, you went to the ER, and we've seen it all the times where medical records, the dictation from the doctor's wrong. I mean, I literally had a client that was beat up at a bar, and his medical records from the doctor said that he was driving on a four-wheeler accident and wrecked the four-wheeler. I don't know if the doctor just messed up his file with someone. Yeah. So you could sit there and tell the insurance company when they ask you, because they're always going to ask you if you had prior accidents, and you say, no, I've never had an accident. I've never had an injury claim against somebody. And they go back and they say, 2 years ago in your ER visit here, it says that you were in a motor vehicle accident. That could literally be a typo. So beyond the privacy ramifications, there's just anything in there they may try to pull out that then you're going to have to combat to try to prove. It's going to create a presumption that you've lied.
Oh yeah, absolutely.
And so all of that kind of stuff. And then the other thing too is just your conversations with the adjusters. Almost every telephone call with an insurance adjuster is recorded. It usually says it at the beginning of the call. It says this call may be recorded, for quality assurance.
Which everyone's so used to hearing, you just go, whatever.
You're like, whatever.
But it's
sometimes if they're doing like a recorded statement, they will say, this is going to be recorded. Do we have your permission? But that's just because they may try to use that against you in the future. Now, just regular conversations with the adjuster may be recorded that they then will go back and listen to. And again, they're going to use anything you say. It's almost like the Miranda rights. Anything you say can and will be used against you. Mm-hmm. Okay, it's not in a court of law, but they may use it against you in the handling of your claim.
Yeah.
Again, if if they ask you, you were in this accident, hey, why didn't you go to the emergency room by ambulance? And you may say, well, I wasn't hurt. And what they meant to say was, well, at the time, I had too many other things going on. I was hurting, but I didn't want to go to the ER because I had my 2 young children in the car I had to handle. I didn't want to pull them along with me to the emergency room, or I had to handle this, or I had to handle that, or any slew of reasons. They may have said, oh, I'm hurting, but I don't really feel that bad right now. They're thinking in their head, I don't want to have to pay for this emergency room visit, or I don't want to pay for this ambulance visit. So there's all kinds of reasons that may have, but in that conversation, they may have just said, no, I didn't go to the emergency room by ambulance. And so that may be construed to say, well, you weren't hurt. Why'd you go 3 days later?
Yeah,
anything like that can be twisted.
Just selective, I guess, verbiage or selective, quote unquote, testimony.
They might pull it out
without context, or absolutely.
So that's kind of one of the big things. And so again, that's going to be starting from the first conversation. And that's why we tell people, if you get a call, if you're in an accident and you get a call and you're even contemplating, seeing a lawyer, and you should just wait. Yeah, I mean, you're not going to lose the right to, you can. In South Carolina, you have 3 years.
3 years, yeah, 3 years.
And if you're worried about your car, I'll tell people too. We've talked about this on podcasts before, that we actually recommend people, if they have collision coverage, to run the actual repair of their vehicle through their own insurance coverage, and that's a whole different story we could talk about. But if you're worried about getting back in your vehicle, then call your own insurance company. Talk to your own insurance company. I mean, that's not ideal either, but at the very least, talk to them just about the physical damage to your vehicle and getting it repaired, and then let them go back and get that money back from the at-fault driver's carrier. Yeah. But, limiting the contact is just critical, because everything you say, they're going to use it against you. They're probably going to try to get a recorded statement at the beginning. Again, some small bit that you don't remember correctly, or whatever, especially any kind of contested case like a red light, green light, accident, or a turning lane, median lane accident. Those things are so nuanced. You need to make sure that you talk to an attorney, and we can review the police report, we can review scene photos and all that, and kind of, make sure we understand what's going on and advise you properly. And then the other thing too is, in that first phone call, you're probably going to get offered some money. And sometimes they'll even mail a check, and you don't even know what it's for. We've had people come in here and they're like, well, the insurance company mailed me a check. I didn't know what it was for. I cashed it. Yeah, and then then they have over. A much, much harder battle to get that release voided.
Right, and just I'm kind of restating what you said, but I think it's another reason why it's so important to call an attorney before making, cashing a check, signing documents, giving a statement, is, sometimes, like what happened with you with the verbal statement, it can be invalidated based off, just material terms being missing, contract principles in general, but, or it might not be, you really might be releasing your claims forever and into eternity.
Exactly.
So it's, it's just, there's nothing to lose from calling an attorney on the front end. Correct me if I'm wrong here, but sometimes when you call an attorney, they say, that first offer, it's not phenomenal, but, it's not terrible. So at least having that piece of knowledge, if you just wanted to say, you know what, I don't want to. Anyways, just to kind of beat the dead horse of call an attorney.
Well, I don't know how other attorneys work, but like you said, we're not going to have any pressure. You want to come in and discuss your case. We can discuss anything that you've gotten in correspondence from the insurance company, any conversations you've had, just so you know your rights, just so you know some of this stuff. And if this helps anybody right now, that's fantastic too, because the enemy here is the insurance company. Yeah. We said, they're not in the business of paying you what you're owed. And so just keeping an eye out for some of these things and remembering that they're not on your side. to use another slogan.
Wait, what?
Yeah. They're not necessarily on your side. And so just keep an eye out and remember that everything you're giving them is just going to be used to defeat your case.
Yeah.
And just to keep those pitfalls, in mind and watch out.
Yeah.
So, and if you ever have a question to call us and schedule an appointment or talk to us on the
Derek
phone.
Harper specifically.
Yes, you can call me specifically.
I'm gonna give him your cell. Is that cool if I put that out there?
If you're in the Lancaster area, for sure. But we have offices all over the state. But we practice all over the state, even in places we don't have offices. But whether it's a telephone call, an email, or an in-person visit, just talk to somebody.
Yeah.
Give us a call and just double check before you do something that could preclude your rights going on, for some minimal amount of money.
Right. Yeah, man. Well, bada bing, bada boom. I mean, I think that wraps it up.
Well, I appreciate it, Charlie. Thanks, man.
All right.
I had a good time.